This is Paul. Yes. I wanted to get these screen prints up. Oh, maybe they won't work. I don't know. I'm just going to try to see if my phone works. Yeah. I had documented what the Washington State Court website says. You cannot continue with the hearing unless there's proof of service. Now, they would say that they tried 2 times within that 50 days, and it says 14 days. It doesn't say 50 days. It actually says that. Oh, now you can't have a court hearing, okay? 50 days after issuing a temporary protection order. You can't make up some bullshit excuse that you're going to do the law the way that you want. Now, you can see here, yes, maybe I can make it bigger for you. There is no signature of the petitioner. Well, the law says King County's domestic violence literature. Yes. The respondent has not been served. Oh, if the respondent has not been served 5 court days in advance of your full order hearing, you must still attend the hearing if you like the temporary protection order to be extended. Ooch. And 2 to 3 weeks to allow time for service is actually 14 days. If you don't appear at the full hearing, your temporary order will be dismissed. You can't issue a permanent protection order if you don't appear at the hearing. That means there's no possible way that you could issue a protection order without the actual signature of the respondent appearing at the hearing. Now, King County, I'm sure, once they get sued, will say, no, our literature is correct. Then I'd go to the actual literature, yes, of the Washington State Court website. Oh. Now, this is kind of interesting. You will return for the full hearing within 14 days. Yes. Bring all your paperwork with you. Now, the judge or court commissioner, Brent Basden, will decide at the hearing whether to grant the order of protection. The court can proceed with the hearing if respondent is present or there is proof that the respondent was served at least 5 judicial days prior to the hearing. If they have proof of service that I would have been served at least 5 judicial days prior to the hearing, well, then they can make that decision. But on number 14, it says the court cannot continue with the hearing if there is no proof of timely service on the respondent. That would have meant, Briston, that you could not continue having a hearing unless you had proof of service, timely and proper, that I, as the respondent, had received that notice and opportunity to be heard. In that situation, you may obtain a reissuance of the temporary order and attempt to have the respondent served. Yes. Now, on June 1st, you had one reissuance hearing. Jack. And there was no attempt of service. I memorized the dates. Then on June 12th, you had another hearing. Did you? Let's just look at it. Now, that's a temporary protection order hearing, and you had 14 days to attempt service. Yes, because you can only issue an ex parte temporary protection order for 14 days. Now, there was an attempt of service, but I was not served. Oh, they can only require 2 attempts of service before you can motion the court for court-ordered mailing or court-ordered publication. Now, you happen to be violating numerous laws. Do you understand that? Okay. And since the actual Exhibit A, that I put a picture of in the email that my public defender had personally put his own little scribble right there. Yes, the court does not have jurisdiction. Now you're going to remove the fucking thing and you're going to end up going to prison. There was no personal service, service by mail, or service by publication. The respondent did not receive actual notice of the hearing. There are no exceptions to the laws of the United States. Now, I know you thought I should just motion the court. I thought that you had to do what the law says. Ooch. I had told you that I can't be complicit or an accessory to your crime of violating the laws. The federal laws known as the VAWA, pooch. The state laws known as the RCWs. And you want me to motion a court that violates the laws of the United States. I'm not going to do it. You're going to go to prison. Now, let's look at Exhibit B. Okay? Because you can have it issued for 14 days, within 14 days. Yes. You have to attempt service. There has to be proof that you attempted service in the court file at least 5 judicial days prior to having a court hearing. Yes. And you can't make up your own fucking rules. Do you understand? Now, you're holding my sons hostage. You've been torturing and terrorizing me for 7 years. And for some reason, you think you can do what you're doing because you're a fucking judge. Well, I am not motioning a court that violates the laws of the United States. Now, for some reason, you think that I should participate in your crimes. I'm not going to. You're going to have to remove them because they are in violation of the state's laws. They're in violation of federal laws. And you're going to have to do it because it's the law. Now, when you really think about it, okay? Every day that you refuse to acknowledge the laws of the United States, you've committed a crime. And you said you could do it because nobody's arrested you. Well, I said you couldn't do it because no one has arrested you, but that doesn't mean you won't get arrested. You have a very flawed way of thinking about crime. Violating the laws means that you will get arrested. And I'm not going to participate in the crimes of that court. Now, I'm just looking for Exhibit B. There are no exceptions, Brent. Do you fucking understand? The law is same for every person in the United States. Now, okay, I found half of it. Let's go back to what the law says. Can you issue a protection order in July of 2008 without any attempt of service? You can't. Can you issue it for another 14 days, 2 to 3 weeks? Right. Without any attempt of service? No, you can't. Can you issue a permanent protection order without actual notice and opportunity? No. Can you issue a protection order by minute order, Brent? No, you can't. You violated the